We're doing how to construct your first offer. This is for agents who are relatively new in the business, but also other agents who have been doing things sort of by, let's just say, by the seat of your pants for quite some time. Let's talk about what we're doing here. Okay, so we're doing it in different steps. The first thing is we're talking about is preparing and working with your buyer whenever possible. And I know times have changed and you can't always do this, but when I started and was working with buyers, I would always tell them that the first time we'll go out and see whatever they would like. And after that, I wanted them to come into the office so that I could explain the process to them. And whenever possible, I think that's one of the best things you can do is get them into a business setting and work with your buyer presentation, which if you've gone through Quick Start, you know where to access it and some of the things you need to talk to people about. You can explain the process. A lot of buyers think they know the process. A lot of the general public thinks they know all sorts of things. And then when they actually get into the experience of it, there are a lot of misunderstandings. So explain the process to them, explain the forms they'll be working with. And this is an excellent time to show them on the MLS system on the Toronto Real Estate Board where to find plain language forms. Those forms are there and explanations of the forms and the clauses in there are highlighted in red. It's a good idea to pull those off, both for yourself, but especially for your clients so that they can preview some of the forms and they're not quite as scary when you get into the actual offer itself. You can explain to them about financing and knowing that you have to have some, guarantee satisfaction that they can get the funds. Have they been pre-qualified? Who is their financing person? Is it okay if you communicate with that person and see what they're going to need and how much the buyer is actually qualified for? You need to talk to them about a deposit and that it has to be available immediately. You have to talk to them about closing dates, when they would like to move, what's a possibility, what isn't. And you start talking to them about their buyer's needs and wants. We have provided you in our buyer package with a checklist, and that will help you establish a good rapport with the buyers, and it gives you an opportunity to ask questions and it gives them the opportunity to tell you what they're looking for. This is the perfect time to explain and get signed working with a realtor and get it out of the way so that you've explained agency. Get your buyer representation in place. Explain the document to them. Explain and try not to get too specific, but do explain to them about the type and location of the property they're looking for. When we discuss location in a buyer representation agreement, we want something specific that we can point to on a map, something like York Region or Simcoe or Toronto. GTA doesn't work because you can't pick that out on a map. Also with the type, don't get overly specific, such as detached double car garage, because people rarely, if ever, when they start getting educated to the market, buy what they think they're going to buy. This is also a perfect opportunity to start talking to them about the fact that you work for a 2.5% commission as a buyer. And if you're going to do any side agreements, this is the time to put them in writing and attach them to your buyer representation agreement, so there are no misunderstandings. It's also a great time to get FinTrack out of the way, because that's a 4-page form that still boggles most people's minds. So if you can get these put out of the way before you even start a property search, it's that much less to do and explain when you're doing the actual offer. Step 2 is viewing the property. And this is why you became a realtor. This is to take people out there, start looking at houses, start tracking the sales prices of the homes that you've been looking at. And that helps you and the buyer understand market value. It helps you manage expectations of a buyer. You and your buyer are developing trust. You're developing a knowledge of exactly what it is they're looking for. And you find, or they compromise on the perfect fit for the buyer for something that is within their budget. They found their home. So after that, you go on to step 3, and it is offer time. And your first steps are, I suggest you call the listing agent if you can get a hold of them, to advise that you're in the process of preparing an offer, and let them know that you'll register it as soon as it's signed. Establish some rapport. Find out as much as possible about what dates and or other details are important to the seller. You can ask if there have been other offers. Will there be competition? Are they anticipating that? When will the listing agent be able to present your offer once you get it signed and registered? And this should give you a good idea of some of the things to advise your client about. At the same time, you're doing a complete and up-to-date CMA, comparative market analysis. If you don't know how to do one, please take a look at our YouTube channel and some of the training there. I believe John does an excellent session on how to do a proper CMA. You want to do it to very comparable properties so that you know a realistic price range and can advise your buyer sort of the value of that property. At the same time, it's really a good idea to do your own due diligence on the property. Some of the things that you should be looking at is investigating, even outside the normal tools that we have as a realtor. Go in and see, do a Google search of the property. See if there are any documented problems with the property that show up on a Google search. Also, go into GeoWarehouse to check your owner's names and details of the property. Do a property line public record search. You can do both of those through the MLS system, and I'll show you where to go for those. Check for a legal description, etc. If you find anything unusual or any discrepancies, call the listing agent. They probably already verified them, or they may not have, and it'll bring to light any problems that may crop up. Another way to check things is to pull the MLS listing. However, I would even go back and check every listing that's been available on that property to see if there are any problems with past listings. Sometimes you'll find a property that's been on the market 3 or 4 times. And if you go back far enough, you may find it was a grow up, or you may find something that's in there that you weren't expecting. But it doesn't happen often, but do your due diligence. And so when you pull the MLS listing, you're checking for the legal address, the seller's names, the listing brokerage, and sales representative. This is all information that you're going to need when you're preparing your offer. And then check the attachments for a Schedule B. I will, and I've spoken about this before, read your Schedule B very carefully coming from different brokerages. If there is any, first of all, if it's a 2-page Schedule B, be very leery, take a look at it. If there's anything in the clauses that looks suspicious or that you're not understanding, run it by your manager. Okay. Also up there, you may find a copy of the survey and any other property documents. When you're preparing an offer, sometimes when you're receiving an offer, but also we've had agents try to get creative and attach things to an offer because they think it's going to bind the listing agent for any errors. Do not attach any advertising to your offer. Builders floor plans, the MLS listing, things like that are not legal documents. Those are advertising. So make sure you don't attach any of those to your offer when you're pulling them off the system. At that point, you're establishing with the buyer the offer price, the deposit, the closing date, the conditions, and other offer inclusions or exclusions that may be applicable to this situation, to your buyers, and to this offer. You're all familiar with an MLS listing. So this is where you find your legal plan, lot and plan, legal description. You've got your address up here, including your postal code. Down here, you've got the seller's names. That's something you're checking on the system for under Geo Warehouse to make sure that names are spelled correctly and that they're the correct names. And then down here, you have the listing brokerage. This is all information you need for your offer. You need to know who the listing brokerage is because usually that's where the deposit is held. But you also want your listing agent's name and contact number on there. Okay. When you just pull up the listing originally, when you're looking at the top of the listing, there are all sorts of links up here. You've got virtual tour, online appointments, web forms, AuthentiSign, Geo Warehouse property line. That's 2 of the ones that we were talking about. I would go into each of those to do a search on them. Other property information, you'll find various things up here. I checked on this one. It was agents out of our Newmarket office that put this up there. So up here under other property information, they do have a copy of the survey. They've got our Schedule B, and I believe the other property information was the COVID forms. So check out everything that is an attachment to the listing. It'll give you all kinds of information. Step 4, you're going to be preparing an offer. If you're a whiz at web forms, you can certainly prepare it yourself. We have templated, we've templated offers for you in the system in web forms. They are in the brokerage area of the program for you. We've done up all different types of offers for different types of properties, whether it's a condo, freehold. We have some commercial offers up there. We've got an assignment offer up there. So you will find mostly everything you need once you get comfortable with it. However, our front desks will do it for you. Either digitally, you'll go into www.virtualoffers.ca, where you can go in and digitally type in information that you want in your offer. It asks you very specific questions. Or manually, if you fill out a cheat sheet and hand it in with a copy of the MLS listing, the front desk will generate an offer for you. Cheat sheets must be completed. The front desks are not allowed to just take your instruction verbally to create an offer. They have to have something written to do it for you. The front desk will generate a Form 801, a confirmation of cooperation and representation, and your offer for you. Please note that you are absolutely responsible for the accuracy of the documents. You must double check everything on there and make sure you review it closely, that it's what you wanted, but also that it is correct. And please allow reasonable time for an offer to be completed. Depending on time of day and how busy the front desks are, we do have 6, 7 offices. We've got people prepared to look after your needs at all of our offices. So if one is too busy to do it for you, they'll shoot it off to a different office to have it done for you. But please be reasonable about it. Usually an hour's time, it seems to be sufficient. So they'll get it done for you. The offer summary document, Form 801. This document is required by the listing brokerage to be kept on file as proof to REPO that an offer was submitted by your buyer. If that offer is unsuccessful, the listing brokerage is required to only keep Form 801. They don't have to keep the full offer. This is especially advantageous to them when they've got, 16, 20 offers on a property. They don't have to keep all the full offers. I will say to you, as a listing brokerage, I would rather see you keeping your offers. However, all you're required to keep is Form 801 unless the offer is from either yourself or from somebody else within our brokerage. When you're submitting an offer to a different brokerage, you are submitting the Form 801. They do not have to return it to you. This is not proof that your offer was presented. If that is something that you require, call your manager. There is a form that can be filled out, or you just ask the listing agent to have the client write on the front page of the offer that they've seen your offer. Some brokerages are requiring you to submit Form 801 when registering your offer. This is not something that I personally recommend myself. However, I don't consider this to be a problem. Go ahead and use it if it's required by another brokerage. Back. Confirmation of cooperation and representation, Form 320. This has to be presented to both the buyer and seller before they even look at an offer or sign an offer. So what you're doing is having it prepared, you're explaining it to your buyer, you're asking them to sign it. It goes along with the Form 801 and with the offer to the listing broker so that the listing broker can explain Form 320 or the confirmation of co-op and rep to the seller. And what this form does is it emphasizes that the listing agent is representing the seller and that you are representing the buyer. It's just clarifying agency, who's working for whom, and where people's loyalties lie. It also notes the cooperating brokerage commission. So be careful there if you're using a commission that is offered in the MLS system at 2.5%, you're fine. If it's something other than what's offered in the system, if you're asking for more money, for whatever reason, make sure that this is agreed to before you send your offer. And also, when you're looking at it, please indicate your commission in the form of either a percentage or a dollar amount, but don't put in there plus HST. We've had these discussions before, It can cause real administrative problems if any change is made to that commission. Okay. So those documents are done before the offer, but they go along with the offer. Here's an example of your cheat sheet. It's quite involved. Get very specific on it because it's generating a legal document. So be careful, make sure the front desk can read it, either type it or print it neatly, I guess, or do it through virtualoffer.ca to do it digitally. Okay. The Agreement of Purchase and Sale Form 100. This document is an offer until you've reached acceptance by all parties. Then it becomes an agreement of purchase and sale, and it binds the buyer and the seller. The brokerages are not a party to this agreement. This is a contract between the buyer and seller. The offer is structured in a very logical manner. First of all of the pre-printed clauses are professionally prepared to outline the obligations of both the buyer and the seller for a successful transfer of title. That's what all of those clauses are in there for. It's to protect both parties, the buyer and the seller, make sure the property is insured and that clear title can be passed on. The brokerages are mentioned for information purposes only in an agreement of purchase and sale and are not bound by the contract. We're not a party to it. The buyers must understand that they need to move forward in good faith and that time is of the essence. When you're explaining things to a buyer, they need to understand it's a contract. Making up your own rules, like doing an offer and then not showing up with a deposit, doesn't help your buyer at all, because all they are is in breach of contract at that time and they can still be sued. So they have to understand that once they're signing that contract, they're going to abide by the terms of it and there isn't any walking away from it unless conditions are not fulfilled. The offer needs to correctly outline all of these items. And this is something that you're putting into your cheat sheet or your digitally into your virtual offer. So it must be correct. The buyer and seller names have to be correct. The property address and location needs to be there. The legal description needs to be there. It needs to be correct. The purchase price needs to be there, the deposit, and where the deposit will be held. And that's usually in the listing brokerage, which is why we get a Schedule B. That deposit belongs to the buyer until closing. The Schedule B was initially brought into the business to describe how that interest that belongs to the buyer is going to be paid to him. Then brokerages got very, very creative and started adding other things that they wanted in their clauses. Understand that this is a contract between buyer and seller and doesn't bind brokerages to anything. Next, you're going to see when the offer is generated, the schedules included in the agreement. Schedule A is automatically generated. That is the one where you're putting in your own clauses. Schedule B is usually there from the listing brokerage, so you add it to your offer. You can usually find it in the MLS listings as an attachment. Make sure it is the correct Schedule B for the correct brokerages. We've seen on more than one occasion where our agents can't find one from the other brokerage, so they slip ours into the agreement. That's not a good idea. If you have other schedules, sometimes if it's commercial offer, they will include a list of chattels that is over and above what can be fitted onto the offer. So they'll create a Schedule C or D or whatever it is. Make sure it's noted on the front page if you are adding schedules to the offer. Irrevocable times and dates must be outlined. A closing date is there. Then you move on to the second page of the offer where emails for delivery of documents show up. And if you are in multiple representation, your own email can't be there. It's got to be a direct email to the client because we are not authorized to accept notices on behalf of our clients in multiple representations. So be careful about that. You've got a section for chattels included and fixtures excluded. We were taught when we got into the business that if you turn the house upside down, anything that falls out is a chattel. Anything that stays in is a fixture. It's a decent rule of thumb, but you have to be careful with it because there are issues with that as well. Sometimes you will have, let's say, a bracket for a television. So the bracket itself would be a fixture, but the television itself is a chattel. So be careful with those things. Also, you've got a section for rental items that are not included in the purchase price. Notably, you're looking at hot water heaters for that, but be careful. We're seeing more and more furnaces, air conditioning systems, some higher price water heaters, that sort of thing, as rental items that they are asking your buyer to assume. If you want those rental items to be bought out on closing, you have to review the contract. You have to make sure that you note that in your offer. We've had quite a few arguments over solar panels. That is a nightmare to buy out on closing. So be careful with your rental items. You've got a title search date, and that's the date by which the buyer's lawyer can notify the seller's lawyer of any title issues. And you've got the present use of the property. Okay, I wouldn't get too specific with zoning on that. It's just present use. And the offer is letting you know that the present use should legally be able to be continued. So that's the beginning of your offer. And those are items that you have to be specific about. Once you get into the Schedule A to the Agreement of Purchase and Sale, we've templated the most common clauses used. We're using OREA clauses. If you go into OREA and take a look at their clauses, there's probably, I don't know, maybe 300, 400 of them. So you should be aware of the clauses that are available to you to use. But we've taken the most commonly used clauses and put them in each offer where they're applicable. The first one that we always talk about in Schedule A is pay the balance of the purchase price. However, if you are working with a vendor take-back mortgage or a further deposit, that would go before the balance of the purchase price because it would make absolute sense. You have a purchase price, you deduct your deposit because the buyer is submitting the deposit. Then if you have a vendor take-back mortgage and a further deposit, you do your subtraction there, and then you have the balance of purchase price that needs to be paid on closing. So for the most part, your standard pay the balance of purchase price clause is fine. Then we put in conditions, both financing and building inspection. These are extremely important conditions. I know that in the market that we are in, people are losing properties, and after the second or third loss, they say, get that out of there. What your buyer needs to understand that both the buyer and the property need to qualify. In other words, the property needs to appraise out. That's where your good communication with your buyer and originally establishing the ability to talk to their financing people comes into play. If you have a good rapport with both the buyer and their financing people, you can call them up and say, listen, we're doing an offer tonight on such and such a property. Do you need the financing clause in there, or are other people good to go? Are you going to need an appraisal? And you adjust your offer accordingly. The building inspection, excuse me, just to let you know, you're looking for major structural issues that would stop your client from purchasing the property. Other conditions that you may want to put in there have to do with the specific property. If there is a well, if there is a septic system, a swimming pool, if your buyers have a property to sell, be wary of not putting in those types of conditions. If any of these conditions, if your buyer says don't put it in, make sure they cross it out. Okay, you put it in, they cross it out. Just a couple of tips for your conditions. Use specific dates, not business days. There is always an issue there. I think our last issue was November 11th because the banks were closed. So use your specific dates. If you have more than one condition in your offer, it's reasonable to line up the dates whenever possible. Just makes it, I guess, easier to understand the whole offer. Okay, we've got a clause in there about a survey. Make sure that you've checked to see if there is one attached to the listing, and then survey if available. Additional viewings, that's another clause that we put in there for you, and it's in addition to any inspections, etc., so that a home inspection does not count as one of the buyer visits. Please, please, please talk to your buyers, make them understand that a buyer visit is not an inspection. They cannot take contractors through without permission. They cannot take building inspectors through without permission. And they can't take the rest of their family through to show them what they've bought without permission. A buyer's visit is just that. It's a visit for the buyers. You can certainly request if you can take other people in, but please be mindful, we're still under COVID, and sellers do not like groups of people walking through the house. Also limit those buyer visits. Set up expectations with your buyers that this is a walkthrough. It isn't time to sit down and start talking, details about decorating so that you're in the house for a long time. That's not what this is for. Okay. Representations and warranties. We have some clauses in there for you. One is that chattels and fixtures will be in good working order. Another one is that there are no work orders registered against the property. Third one is that the property has not been used for any illegal uses. And a fourth one is detrimental conditions. Detrimental conditions is a little bit of one that some lawyers will have a problem with. Lawyers say there's no such thing as a stigma on the property. The fact of the matter is there probably is no legal stigma on a property. However, if something has happened in that property or there is some sort of a detrimental condition that would cause your buyer not to buy the property or would change the market value of the property, you want to know that it's in there. But you also need to have your discussion with your buyer as to what would stop them from buying a property. So, but we do have that clause in there for you. Then you have clauses about agreements. One of them is the use of electronic signatures. Another one is that the seller will remove personal belongings and leave the home in a broom swept condition. And the last thing that's usually in the offer is definitions. And we put in on your buyer's offer a definition of banking or business days. If any of these clauses conflict with what's in the listing agent Schedule B, make sure you take a look, make sure they read word for word what the other clause says, or remove one of them. You don't want anything in an offer that can be interpreted in two different ways. Signature page has the buyers and sellers' signatures on it. You cannot witness a signature if you did not see the person sign. Digital signature, you will pull the digital certificate. We have had in the past other brokerages ask us to have a digital signature witnessed. We can't do that. If you're sending something by email to your clients where they print it out and sign it, have someone who is with them be physically present in their location to witness their signature. It cannot be a relative. It can't be a spouse or a child. I've had signatures come back where the husband witnesses for the wife and the wife witnesses for the husband. That can't happen. In person, if you're seeing the person sign the document, you can, of course, witness it, and you should if you're watching them physically sign the property. Spousal consent, I'm only mentioning this here just for clarity. Excuse me. When you are the buyer, you're not working with spousal consent. As a listing agent, the seller may be working with spousal consent, but understand that spousal consent is only for a matrimonial property of legally married spouses. Common law relationships do not come into this contract. The parties to the agreement, if it is a common law situation, they may have a lawyer dividing assets or whatever it is they're doing. That's outside of the scope of our agreement of purchase and sale. This only applies to matrimonial property if one spouse is not listed as a seller. Confirmation of acceptance. The last person to touch the offer acknowledges that everybody is in agreement with all of the details of the offer. We've had issues where they want both parties, if there are two buyers, they want two buyers to sign it. If there are two sellers signing off the acknowledgement, they want both sellers to sign it. It doesn't hurt to have both of them sign it, but the fact is you only need the very last person to touch the offer to sign off on it. And that's the end of your contract. Everything under that confirmation of acceptance is there. It is necessary, but it is not part of the contract. It is for information purposes only. So you've got things like information on brokerages. You want the information, but it isn't part of the contract. You've got acknowledgements here. All this does is acknowledge that all the people who were to get a copy of the contract got one. So it isn't part of the legal contract, but it notifies you that everybody got them. And then the commission trust agreement, again, is a part of the offer that we feel is necessary. What it does is it shows our governing bodies that we have entered into a commission trust agreement. Although we are not bound by this document, it is used as, I guess, evidence if ever we have to sue. What else? Okay, so please make sure, just some notes, that you've listened to me talk for 40 minutes. Oh my goodness. Please make sure you have your first 2 to 3 offers reviewed by your manager before you present it to your client for signature. Nothing worse than having to go back as a new agent and say, oops, I made a mistake. Please, let's fix this. So go to your manager. That's what we're here for. You must explain all documents and the offer in its entirety to the buyer before they sign it. I know that's pretty self-evident, but now we're flipping around with Authentic-Sign, and some agents are good at just pointing and saying, sign here, sign here, sign here. That's not good enough. You have to make sure that the buyer understands everything. It's one of the reasons that in the beginning I said, give them the plain language clauses. Then when you're explaining how you work with them, you can go over the offer again with them. And now that they're actually signing, go through clause by clause. Don't have to go through the pre-printed clauses if you've already covered off on that. But everything that you put in the document, make sure you explain it to them and that they're clear on it. If the buyer wants to remove a condition that you've included in the offer, please, please, please have your buyer cross it out, initial it, and then have them complete a Form 127. It's called Conditions in Offer Buyer Acknowledgement. And what this does is it shows that they understand the action of removing the condition. It is absolutely a document to protect yourself. And just off the record, I will tell you that our professional agents who have been in the business for years use this all the time. They never go without it when they're removing a condition, because too many times when something doesn't go the way a buyer or a buyer's lawyer feels that it should have gone, the first thing they do is talk to us about the buyer not having understood what they were signing. Keep your buyer informed in every step of the process. Make sure the explanations are there when you're not hearing back from the listing agent, or if there are verbal discussions or whatever it is. Please make sure your buyer is available to document any changes during negotiations. This is one that seems self-evident, but I've had clients go to bed and then you can't reach them within irrevocable times. So it's just another discussion you're having when you're talking about how to do the offer.
Thank you so much for watching. If you like our video, please hit the like button, the subscribe, and even the little bell to get notifications, just so you can stay in touch and watch more of these great videos.